We're back, we're live, we're ThinkTech, doing ThinkTech Talks here at the 3 o'clock block on a given Wednesday. We're here with Jerry Clay. That's Jerry Clay. He's the lead chief partner and bottle washer, is that fair to say?
Absolutely.
Of Clay, Chapman, Iwamura, Pulice.
Close enough.
And Nervell, which is a block away here you're in the Topa, which I always refer to as the AMFAC building. And I also refer to 6th Avenue as 6th Avenue and Macy's as Liberty House, among other things. I'm stuck in that, yeah.
But we're from the same era, my friend.
Okay. You call it 6th Avenue, too. P.S. The short story is they changed it to Avenue of the Americas back in 1955, I think, and I just never got used to that.
Anyway.
We're going to trade old sea stories here. Another look at mediation is what I'm titling the show.
Okay.
I'd started with, is mediation what it's cracked up to be? So that's inherent in another look at mediation. And Jerry is essentially the king of mediation at this point, you know. All the others.
Meaning that I'm the oldest one in Hawaii who is still alive promoting it.
Exactly. Exactly. I couldn't have said that better. Jerry and I know each other, I don't know, 30 years, something like that. At least it feels longer. It's a lifetime thing. And, I think it's fair that we talk about mediation because mediation is modern. Mediation is what's happening. Mediation is it's kind of a variation on the old theme. Just for background, 2 weeks ago at this table, there were two Chinese guys from China that came. And one was the managing partner of a 3,000-man law firm, and the other was a professor in a prestigious law school. And they were here with Shackley Raffetto to join him, the retired judge from Maui. And he has a thing going with moot court practice in China. And these two lawyers came to Hawaii for one reason, to see the jury system. They wanted to observe a jury, and he gave them that chance here in the First Circuit. And they were really astounded with it because don't have that in China, and it is a great, to them, a great icon of American justice, which is desirable. I don't know about a legislative process, but American justice is more desirable in the world than American legislative process these
We'll
days.
get into that a little bit.
Okay. So, that's the backdrop of it, is that we have a great system in going way back into English common law and all that. They have civil law. They want to do precedent. They want to come to our side of the equation. We have an admirable system, and yet it's not so admirable that an alternative system isn't so popular.
Well,
what happened? What happened here?
Can I address it, Jay?
Yeah.
What's happened is that we really haven't analyzed and critiqued our adversary system of justice.
Okay.
And what I have been doing last year, particularly this year, I'm president of the Mediation Center of the Pacific.
What is that?
That is a 501c3 charitable organization that provides volunteer mediation services to the courts, to divorcing couples. Last year we helped more than 5,000 people mediate disputes. And I would like to use that forum as president to change the mindset in Hawaii from solving relationship-based disputes from litigation or from any adversary process, including arbitration, to mediation. Can I expand?
Please. I need to know more because I'm not unfamiliar with this, and yet I am unfamiliar with it the way you put it, so tell us more.
Arbitration and litigation are processes by which we determine who is right and who is wrong. And that very philosophical base is a very poor base for settling relationship-based disputes. In my analysis, there are three types of disputes that go to court. There are criminal disputes, and we have the vaunted best system in the world to determine whether somebody is guilty or not guilty. They go before the court or a jury or a judge, and in order to deprive them of their freedom or their wealth, they have to be found guilty beyond a reasonable doubt. 99.9% they have to be wrong. Now, that accounts for maybe 10% of the cases that are in our courts. The other 90% are civil cases.
Yeah. Now, you're not concerned with the criminal cases.
I'm
right?
not concerned with the criminal
Because
cases.
you can't mediate whether he committed the murder or not. It's an absolute.
Right.
At the end of the day. Yeah.
Yeah. And the court system says to make sure that we don't have an innocent person found guilty, you have to be convinced 99.9%. That's the amount of truth that you have to prove in order to convict somebody. Now let's go to our civil system.
Okay.
Okay? What is the standard for having a winner in the civil system?
Is this a short but subjective question you're putting to me?
Well, you've been a lawyer, you know the answer,
I
of
would
course.
say the answer is preponderance of evidence.
Okay, quantitatively, we go from 99%
To 50.1%.
to 50.1%. Kind of ridiculous, isn't
It
it?
is. It's a huge difference. I hope the juries understand that. I don't think they do.
When you get to civil cases.
Yeah.
Okay. Let's talk about the two types of civil cases that get into court. There are those that arrive in court because people accidentally have a dispute with one another, an auto accident.
Yeah.
All the other disputes come to court because there's been a relationship that has gone bad.
Okay. Strangers versus somebody in a relationship.
Okay.
A business relationship, a marital relationship, a partner, whatever.
Landlord, tenant,
Okay.
vendor, vendee.
Anything. There's
Anything.
so many possibilities. yeah.
Okay. And if we analyze how relationships work, they do not work by having winners and losers.
No, it should be win-win, ideally. And if it's win-lose, it's not sustainable.
Okay? So, a relationship works that people are constantly in a relationship talking.
There.
They are
But some people don't do that, you know.
in a relationship, they have to, because if somebody is always being silent or always trying to win, the relationship won't go on very long.
Again, not sustainable. Yeah.
Right, not sustainable.
Yeah.
So, what happens in a relationship to end up with a dispute? You have people who normally talk, this could be weeks, months, years, decades, and all of a sudden, something arises between the parties in the relationship that becomes so important that they put emotion onto their position. They get an emotional charge. They can't compromise. They get to the point of saying, I am right, you are wrong.
And I'm angry at you.
And anger may be something, disappointment may be something. All these emotions come in. And so, how do we resolve those relationships in our society right now? We go to a lawyer. And what is the lawyer trained to do to resolve these relationship-based disputes?
He's trained to go to court.
He's trained to use the adversary system of justice. And so he's trained to go to court, and he's trained to be able to prove his side is 51% right, and the other side is less than 51% right. Kind of ridiculous. So how does the lawyer go about it? He then uses all the tools of the legal profession to show why his side is right, the other side is wrong, including trying to show that the person on the other side has no credibility.
To say nothing of all the procedural tricks involved.
Right. And you're beginning to get the idea, this is not a good system for all the disputes that come out of a relationship. In fact, it's a bad system.
Well, it's going to, if the relationship had any hope of survival after that, it won't.
Probably. Probably. And so let's take a look. Back in the 1980s, the late 1980s, I did some research and wrote a book called Before You Sue. Did some research, and coming out of that, we tried to determine how many civil cases are filed every week in the United States. And it's very hard to get good numbers, but we came up with a number like 60,000 a week.
That sounds right.
Okay.
On a national level.
On a national level.
Yeah.
So Jay, let me ask you a question, really a rhetorical question. At the end of those cases, do we get 60,000 winners and 60,000 losers?
No, it's probably more like most of them are losers. I mean, because I think the object of litigation is to hurt people. Well, I shouldn't say always, but frequently it is, and everybody gets hurt in the process. They get hurt by winning something they shouldn't have won, or by losing something they shouldn't have lost, or by paying a lot of money to get a result they didn't like.
The lawyer is going to represent his client to win. Our legal system is what's called a binary system. There are only two possibilities at the end.
Right.
Win or lose.
But even the winners sometimes lose.
So what percent of those 60,000 cases, what percent quantitatively of those 60,000 cases end up with a winner and a loser? And I'll give you the answer if you don't know.
Right. How many? 3.
It's between 3 and 4%. 95, 96% of those cases never end up with a final decision.
Because they get settled.
Well, party dies, party goes bankrupt. The vast majority of them settle. But they settle only after the expenditure of huge sums of money, even a greater expenditure of productive time going into non-productive activity.
Are the settlements good?
Of course settlements are
Are the
good.
settlements as good substantively as a mediation would result in? As accurate, as on target, as reflective of the truth and a sort of a common sense fairness.
You're going into another issue, and I'll go into it now.
Yeah,
as you like.
well, we're just schmoozing here.
Okay. Mediation is not based on determining who's going to be a winner or loser. That may come up, but it's not based on that.
Well, yeah, certainly it will come up in the sense that if you go to the mediator will say in the privacy of your discussion with him, he'll say, Jerry, you're going to lose this if you go to court. You don't have a good case, so soften.
A good mediator will go in, and with the attorney on the other side, if there is an attorney, in most cases they're in, he will ask, do you guarantee a 100% win? How about 90%? How about 80? How about 70? How about 60? How about 51? Do you guarantee 51? But that's only one element of mediation. Mediation has a totally different philosophical basis, and that basis is maximizing each party's interests. And that is not necessarily only based on the fact that you could win or lose. It's based on a whole host of things, including seeing if some of those emotions can't be satisfied. How can you satisfy an emotion and settle a case? Well, there are numbers of ways. Sometimes it's something as simple as saying, that son of a gun is not going to get away with it, and the other side saying, I may have gone over the line, and the mediator suggesting, you know what? Maybe an apology could go far to getting this thing settled.
I apologize to you now, Jerry. I apologize to you now because we have to take a break. And I'm going to have to hold on your rhetoric for just a minute, okay?
I accept your apology.
Thank you. I have just apologized to Jerry Clay of Clay, Chapman, Iwamura, Pulice and Nervell, a law firm in town. They do a lot of mediation and arbitration there. Here in our ThinkTech Talks program, we're taking another look at mediation. I'm Jay Fidell. This is ThinkTech. We'll be right back after this short break.
Aloha. I'm Nicole Horry for ThinkTech. For nearly half a century, the Hawaii Foreign Trade Zone No. 9 has brought the benefits of the Foreign Trade Zone program to Hawaii businesses and entrepreneurs. DBET, the Department of Business, Economic Development, and Tourism, operates Hawaii's Foreign Trade Zone program to encourage international business and economic development. The Foreign Trade Zone's mission is to increase the amount of international trading activity in Hawaii, thereby providing employment opportunities for the residents of our island state. For more information, see ftz9.org. I'm Nicole Horry. Mahalo.
We're back, we're live, we're ThinkTech here on a Wednesday, in the ThinkTech Talk, if you will, talking with Jerry Clay, a lawyer who is the king of mediation, arbitration. Fair to say that. You're not arguing with me. He doesn't argue with anybody, actually. And we're taking another look at mediation. And I wanted to, I wanted to advance the discussion into why you do this. I mean, this is, I suppose, you practice and there's an economic result of being an arbitrator, mediator, or a lawyer involved in arbitration mediation. But there's also something else happening here. You want to make a better life for the people who come before you or to you for mediation arbitration services in the belief that this will give them a better legal experience. Well, what is it that makes you want to do that?
I guess, Jay, it goes back to 1984. I'd been practicing for about 20 years, and I was trained as a commercial mediator, and it's like a light bulb went on. And I said, so much superior than this adversary system. And I began to think, America could be so much better if we took our disputes that came out of a relationship and mediated them before bringing them to a judge or jury to decide who's right and who's wrong. Because it's very rare that there will be a dispute where one side is 100% right and the other side is 0% right.
So this is actually something that, I know exactly what you're saying, and I absolutely agree, but the system had gone the wrong direction. Maybe it was always in the wrong direction in terms of civil disputes. And you identified that and you related to that and you wanted to fix that, do what you could to fix it. And I think there's a lot of people out there, and I would like to examine that with you. I mean, was this always flawed? And we've left jury trials in criminal cases and the whole criminal process off the table today. We're not talking about that. We're talking about civil disputes, relation disputes, and all that. Was it always wrong? Is it that we should have thought of this many decades before, even at the time of the framing of the Constitution? Why did it take so long for us to get to this wisdom?
That's a very good question, Jay. And what's interesting, and I've done some research lately, there still aren't very many legal commentators analyzing this adversary system as applied to civil disputes. It's like we adopted it. I'll never forget when I started law school. And the dean came in to the entering freshman class, and he starts his talk by saying, "You're about to undertake a study of the adversary system of justice. Take one lawyer fully prepared on one side, take another lawyer fully prepared on the other side. You bring them together in the clash of the courtroom, and the truth will emerge, and that is the pearl of the universe." And we have just adopted a mindset that this is really superior to everything. We have not analyzed it, we have not critiqued it. Today, I have found only 2 legal scholars who are writing critiques of the adversary system. There's a lady about 20 years ago who went through a terrible divorce proceeding that was finally mediated, who afterwards hated this adversary system so much that she went out and wrote a critique about it. It's a book called Injustice for All, and what she did...
That's beautiful.
Great title, isn't it? What she did is she went to the law libraries and said, how many books are out there critiquing the adversary system? And out of the millions of volumes at Harvard Law School, she found 0. Same thing at other law schools. We have never analyzed it. We have never...
So is there a movement now? Are you part of a national movement that is trying to make that analysis and trying to fix what is broken?
To the extent that I have researched, I'm kind of like the new one. I haven't seen other people arguing the way I am, that the adversary system is a poor system for relationship-based disputes, and interest-based, philosophically interest-based dispute resolution is far superior.
But it doesn't have to be like that. I give you what happened, at least in my practice, and that is more and more the judge would focus on trying to settle the case, especially, in all kinds of civil disputes. And I can remember Ron Moon, the former Chief Justice, he was really good at that. So you had the possibility of settling every case in the judge's chambers. And of course he would say, you're going to lose in trial in front of a jury, and you're going to win, and you ought to soften or harden your positions, whatever, and come together. And then he talked about having a a red book and remember this, and a purple book. And if you didn't play fair in the discussion in chambers, he was going to remember that, and you wouldn't like that. So, maybe that should have happened earlier. That kind of, what do you want to call it, settlement practice. Maybe it should have been more robust. Maybe the judges should have been trained better at what to do with
one
chambers.
other suggestion?
Yeah, go ahead.
Maybe they never should have gone to court. Maybe they should have gone to a mediator.
Okay, I'm just talking about, forgetting mediation for a minute. Could the existing system, the primary system, the main system that emerged,
The adversary system.
The adversary system has gotten softer because judges do spend more time in trying to settle cases in chambers. And I agree with you absolutely. The flaw there is you just spent hundreds of thousands getting that far.
There's another flaw.
Yeah.
You're only looking at the chance of winning and losing. You're not looking at all the other perspectives that are part of the relationship. You're not looking at how to maximize each side's interests. While in mediation, you can go into everything. You can go into letters of apology. You can go into new ventures. You can go into, it's limitless as to what you can do in helping people restore relationships. While the judge is only going to say, you win, you lose, you settle, because he's going to lose.
Well, they get more creative. I remember, it was a foreclosure, and then it was a bankruptcy involved a hotel in Maui. And I think it was Keith Hunter, who did this. He got involved. He was a court-appointed mediator, arbitrator, something like that. And he got them to reorganize the ownership of the hotel completely. This could never have happened, in a
settlement conference.
Right. And so it was because it was a creative approach. He was willing to really listen to what they were saying. He was willing to think out of the box and come up with something that actually worked for everybody. At the end of the day, it was a brilliant solution for a very complex problem. And it happened within, I want to say, the confines of the conventional system.
No, it didn't. It happened in a mediation with Keith Hunter, which is outside a settlement conference. There's no judge. He's not looking. That's
right. They brought in the special situation with mediation.
A mediator.
So they sort of bounced it out of the formal procedure,
exactly.
and they got that. So, but that's where it often happens, doesn't it? You're talking about mediating before you ever go to court, and I agree with you. That is admirable. That is the best solution. Sometimes the lawyers don't recommend that, honestly, and I'm going to talk to you about what kind of advice they give about that. But there'd be less pressure on this issue, don't you think? That if in the conventional system, and there's something in the district court about this, right? You must mediate certain kinds of disputes, right? Before you go to court.
If you're in small claims court,
yeah.
The judge will send you out into the hall, and there'll be a mediation center of the Pacific volunteer mediator who you must spend 20 minutes with. He actually settles 60% of the cases that go out there. So when you come back to court, the judge says, settlement? If not, I'll hear your case. But yes, every small claims case goes to mediation automatically. Same thing happens in TRO court. Every case goes to mediation automatically.
And in the automobile accident cases, you have to go to an arbitration, right? Yeah. As a matter of law, you must do that before you can go to court.
But philosophically, that's a different perspective.
That's a different perspective.
Because we're back to win-lose.
Yeah, right. Well, you get an arbitrator's hard result,
right.
Whatever it might be.
Instead of having a mediator see how can we restore this relationship? How can we bring in a brand new business deal to come out of this?
Okay, let me ask you a big question. Is there no case which you, Jerry, would say should go to mediation? Is there a case out there which say, forget it, you guys go to court, I can't help you?
Yes, of course.
What kind of case is that?
Where you're trying to set a legal precedent. Tobacco could never be mediated. Okay? You can never mediate abuse. That's, in a civil case, you got to go to court on that. Maybe you can mediate damages out of an abuse case, but you can't mediate those kinds of wrongs. They're 100% wrong. Can't mediate.
You have to have your day in those cases.
That's where the system of right and wrong comes in.
Yeah. But they're ordinary people, ordinary dispute, relationship dispute, then in every case, is this your contention? In every case, it goes to mediation. It should go to
Absolutely. There's no reason not to. There's no downside.
So why don't lawyers do that? I mean, we've been watching this a long time, you and me, but they've seen the flowering of mediation. They've seen it, you know, when we started practicing, wasn't that much of it. Now there's a lot of it, relatively. So why is it that lawyers are still advising their clients to go to court?
Because that's how we're trained. Law schools have a single course to train you about how to do mediation, but you are trained to think like a lawyer, which means you are trained to think how to use the adversary system to win. I'll never forget a professor who came in one day smiling from ear to ear because he just heard from one of his students who had just won a case, a motion, on the opposite side of what she had argued 2 months before. And this was absolutely the supreme training that you could give. That's how we're trained. We have a mindset for that, and society has adopted it. Remember, the dean got up there and said, this is the pearl of the universe, and that's what our mindset is. What I hope to do in the next 2 years is change the mindset.
2 years? Why 2 years?
I have a 2-year stint as president of the Mediation Center of the Pacific.
The one you talked about.
Yes.
Yeah. So what does it mean to be president of the Mediation Center?
I'm going to instill some programs that hopefully are going to begin to change the mindset.
What are they? Can you talk about it?
Of course.
Please.
Thank you, Jay.
I mean, if you told me it was confidential, I would accept that, but there's no reason. Because when we talk about this kind of alternative dispute resolution, a lot of stuff is on the table. It's transparent, much more so than in an adversarial, strategical kind of dispute resolution. So,
What we need to do is go and get the public to have a change of mindset that when they get into a dispute with somebody they've been in a relationship, to not think lawyers, lawsuit, court, but to think mediation, mediator. And I've given a lot of thought, how are we going to do that? And I've come up with an idea called the Hawaii Mediation Pledge.
oh, is it contractually binding?
No.
But
The idea is that what we want to do is to get people to change their mindset. To begin to think when they have a dispute, I don't want to go into court, I want to get a mediator.
so you want to catch it before they get to that lawyer who is going to be giving them an adversarial advice.
Right.
But maybe they don't understand their rights. I mean, maybe they're entitled to $1 billion, and going to a mediation will just not, you know, they will not be incorporating the full knowledge of what their claim really means legally. How can he make this person this decision without knowing that his claim is really worth $1 billion?
Okay. And what you're getting to is the one most difficult problem about mediation, and that is the quality of the mediator. If you had a mediator in that big case you were describing who came out of a background of understanding that kind of claim, that mediator would then bring that experience to those parties. If it's that big a claim, the parties would probably have to have lawyers to advise them. But you need that mediator with the experience, you need with the respect that would be generated. And that is the one biggest problem with successful mediation, is getting the right mediator.
Yes. That is a perfect place for us to take our second break, Jerry. Again, apologies. That's Jerry Clay, fabulous lawyer, great mediator, and a good person, because he's delivering good things, not only to the law practice, but to the community in general. And that's what ThinkTech likes. He's with Clay, Chapman, Iwamura Pulice and Nervell, right here in the Topa Tower down the block. And we're talking about mediation. We're taking another look at mediation. We're asking whether mediation is what it's cracked up to be, and we'll find out more right after this break.
I'm Bill Spencer, president of the Hawaii Venture Capital Association. We do monthly luncheon programs with ThinkTech about things that matter to Hawaii entrepreneurs, investors, and business service providers. So join us on the fourth Thursday of every month at the Plaza Club. For information about upcoming events or to join our mailing list, visit hvca.org. See you there.
Okay, we're back. We're live. This is a ThinkTech Talks on a given Wednesday. And we're taking a look at mediation. Another look at mediation is mediation, what it's cracked up to be, with Jerry Clay, who's a par excellence mediator, lawyer, and lawyer involved in mediation and arbitration, alternative dispute resolution. You know, way back when mediation wasn't that popular, I thought it was really the cat's meow, because you didn't have to wear a coat and tie. And you'd have to go to court and bow and scrape and do all those things. You could just talk to the people. Just talk to the people, and you could make deals and find creative solutions and all that. And you go with a sheet of paper, make your points. You, as you said before, you care to have a really good mediator who could be in tune with these things, who wouldn't be trying to hurt anybody, who'd really be trying to make deals, and that was a good thing. But then I noticed, and when you went to court in those days, big trial binder, you know, one of those little carriers where you carry a legal case, you know, big, you know, and you needed 3 people to carry all the files. And so you didn't have to do that in mediation. But it's changed, Jerry. See guys going to mediation, and for that matter, certainly arbitration, they're carrying the big filing boxes. They have a big binder. They want to be sure that they don't miss anything. It becomes a little like, you know, going to court, and it becomes much more expensive than it was when we just sat around and schmoozed with our feet on the table. Do you agree with me?
No.
I didn't think you would. Time for another break. No.
Let's talk about what is mediation. Everybody knows what negotiation is. It's talking. And as I said earlier, what happens in a relationship is we got to a point where each side felt that they were right and they couldn't talk anymore. And what mediation is a system.
Psychology.
Yeah.
Really
Well, it really is. What you do is you bring in a third person who then can begin to bridge so that people start talking again. What mediation is nothing more than negotiation. And there was a term going back to the 80s that got coined that I still like to call, it's turbocharged negotiation.
Why is it turbocharged?
Because you bring in a third party who helps the people hear one another.
With skill, special skill.
They have a lot of training.
To get the points out and make the thing work. Yeah.
Right.
So if you just do that by yourself, you know, it's the old story of the husband and wife having an argument at the kitchen table. That's where those things happen. And they can't resolve it. They get more and more angry. When they go to some professional, and the professional helps them work it through, they reach an agreement they could never have otherwise reached. It's a parallel to that, isn't it?
It's exactly that.
Yeah.
It's not even a parallel. People, for some reason, when they become emotional, don't hear the other side. Or perhaps it's ingrained that they don't hear the other side. One of my favorite mediation stories. Love to tell
Please.
stories.
This will be the first story today. Yeah.
Okay.
So we like stories. Here on ThinkTech, we like stories.
Woman goes to a lawyer to get a divorce. Lawyer starts his interview by asking, do you have grounds? And she says, oh, yes. As a matter of fact, we own 22 acres outside of Kahalu. And the lawyer says, that's not what I mean. Lawyer says, do you have a grudge? And she says, oh yes, as a matter of fact, it's big enough to hold 3 cars and we only own 2. Lawyer's getting frustrated, and finally he looks at her and says, tell me, does he beat you up? And she says, you don't understand. We don't even use an alarm clock. I'm first up every morning. Finally the lawyer says, just tell me, why do you want a divorce? She says, it's simple. We can't communicate.
I'm I'll tell you who I would side with on that one.
Okay. All mediation is reinstituting talking about for people who got so emotional they can't keep talking. Or sides. I mean, big businesses get into disputes. They're both right. I can't tell you how many are going on in my office right now. Each side is right. And what we're doing is we're going through a dance to prove the other one is wrong so we can finally get to a settlement conference or a mediation where we can finally get somebody else to talk between us and show us why some things may not be as positive as we emotionally think they are, but more importantly, what other avenues can we seek out to increase our interests, maximize the result?
So you have to work at that. This doesn't come automatically. And to go further, not every mediation results in an agreement, and sometimes they go off the side. Why do they go off the side?
I'm at a point in my career where I believe, given enough time, given enough resources, every relationship-based dispute can be resolved.
That doesn't mean every marriage can be put back together.
No.
I guess I agree with you. Given the right, assuming that you can work with the people and that they are ultimately rational and, what do I want to say, self-interested but rational, you can. It's reasonable men can make an agreement.
Can I go back to the statement you just made?
Yes.
The more important thing is self-interested rather than rational. Because
Okay.
what is most important in a lawsuit, as it comes down to the end, is not necessarily being the winner, but not being the loser.
Right. So if you're doing something really silly, that's not in your interest.
Right. Good mediator will find the way to get that message through, even to somebody who is emotional and doesn't want to see it. But you have to have enough time, enough resources, and then you have to have a mediator who is very creative to find those ways.
You mentioned that before, and I want to spend a little time on that. So here I am. I'm investing, my money, my time, my face, my relationship, my business maybe, in this mediation process. And as you said a couple of times, it's trying to find a good mediator, trying to find the perfect mediator who can do the best job. How do I do that, Jerry? This is not easy. Because, there are people out there who won't do the best job. How do I spot the good ones and spot the bad ones?
It's a matter just like any other matter in a market economy. There are reputations. People are out there who you can ask questions about. It's not
Due diligence.
due diligence.
In the community, Google, what have you, the whole
Right.
thing.
Right.
And what am I looking for? I mean, looking for somebody who has negotiated or mediated good results in X% of his cases or her cases? Am I looking for somebody, his background, or maybe all of the foregoing?
All of the foregoing.
But how do I find I don't have a clunker? I mean, I want to be sure I don't have a clunker.
Right now, if your case is large enough that you have a attorney and the other side has an attorney, they know who in town is good. And they will advise, and most likely you'll end up with somebody who is good based on reputation, just like anything else. Just like the right lawyer, the right doctor,
Sure, same
the
thing.
right dentist. I think as mediation begins to grow and more people become mediators, there will be new ways for people to identify those who are constantly successful.
So what attributes am I looking for? I'm looking for somebody who's fair, obviously, who can listen, who knows the law and knows cases. I mean, he, as you said before, he should be able to tell me if I have a $1 billion case, because I've got to get it from somewhere. If not my own lawyer, I want it from him. He should come up, he's got to be creative. And my own test of it is he's got to be kind. I mean, the best mediators I've ever met are the ones who have an abiding sense of kindness.
And fairness.
Yeah, yeah.
And people will have different kinds of skills, and there may be different kinds of experience that's necessary. I mean, it's good to have industry experience in the area in which you're mediating, so that you don't have to have the mediator to learn about something
I make
from
a mistake
scratch.
learning. because he may not learn the thing correctly.
Let's assume both sides are sophisticated, they have lawyers. It's unlikely that the mediator will make a mistake because you've got a lawyer there to correct him. And the way the mediation process works, the lawyer is going to be meeting confidentially in a caucus with one side, and before he leaves the caucus, he will review what he's going to go tell the other side, so that it's unlikely that he will communicate something in error.
So you get a reality test process.
Every time.
And if you're way off the mark, they're going to tell you. Somebody's going to tell you.
Even if you're just off the mark a little bit.
Okay, yeah, thank you for that.
People are
That's
emotional.
absolutely so. We're going to take a short break again.
Okay.
I'm sorry about this for the third time, but hey.
Okay.
We're going to mediate our way through a short break here with Jerry Clay. We're doing a look at mediation. Another look is mediation, what it's cracked up to be. Jerry is a very senior mediator and arbitrator and lawyer dealing with those procedures. We'll be right back after this break. Aloha, I'm Jay Fidell, founder of ThinkTech Hawaii. We are a digital media nonprofit that covers things that matter to tech, energy, diversification, globalism, and progress for our state, the state of Hawaii. We broadcast on community television and on Oceanic Cable Channel 16. We also stream our shows and interviews live on the internet as both radio and video, and of course we post them here on YouTube. We collaborate with the Hawaii Venture Capital Association to present monthly luncheon programs on subjects of interest to the business community, and we write for the Honolulu Star-Advertiser. ThinkTech works hard to raise public awareness in Hawaii. Check out our website, thinktechhawaii.com, and come to our YouTube channel, ThinkTech Hawaii. We hope you support our mission and that you like our work. I'm Jay Fidell. Mahalo. We're back. We're live. We're here with Jerry Clay of Clay, Chapman, Iwamura Pulice.
Pretty good.
And Nervell, the law firm in Topatawa, just the other side of the street. And we're talking about mediation. That's because Jerry spends all his time in mediation on other people's disputes, or as being counsel for somebody, or as being a mediator. And he has learned the traits that are necessary to succeed in this area, that's to his credit. And we're talking about whether mediation is what it's cracked up to be. And I wanted to ask him about the trajectory. As a matter of public policy, as a matter of how our society works, we want our society to work better all the time. It's not, it's not without its flaws right now. We always want to improve it. You are involved, in being involved in alternative dispute resolution and specifically mediation, which I get the feeling from you is really is less adversarial than arbitration is, of course. So it's the noblest approach of all.
I like to think so.
I know, I do. I agree with you totally. It's making people be kind to each other. It's being kind and sharing the kindness.
No, that's not what
Sharing
it
the
is.
self-interest. Giving them a reality test.
It's determining what's in your own best interest. That's correct.
All right, I accept that. But I wanted to ask you here in the last part of the show, what is the trajectory? For a period of time, we didn't have a lot of mediation. It was an aardvark kind of thing back in 30 years ago. It's become much more popular. There's been all kinds of activity in the Bar Association around it. Where is it going right now, and where do you think it'll go in the future?
Let me spend about 3 minutes with history. There has been a lot of mediation in the past, but it's been limited to the area of labor law, labor relations.
Right. It was in NLRB. It was in the National Labor Relations Act, federal statute.
Let's talk about why that happened.
Okay.
It started out with the Railway Act of 1918, where the government had to get men and material across the country onto the boats to go fight a war in World War I, and they didn't want to have labor strife. So they passed a law that said no union can go out on strike until they've gone through mediation. And this is so important, we're going to have government money fund an agency where we'll have full-time mediators to reduce labor strife. And since 1918, we've been having labor mediation. 1947, we had Taft-Hartley, which, we have full-time government-paid mediators for the labor area in Hawaii. Wasn't until the early 1980s that it began to gain traction outside of the labor area when the American Arbitration Association began to see there was a new business out there, and that was selling mediation services. And they ran around the country training people to be commercial mediators. I was fortunate to be one of them. And that started a trajectory of saying, when cases go to court, at some point we're going to try to mediate them. And that basically set us up on a trajectory of having a lot more mediation, but it still doesn't change the mindset. We still go to a lawyer, we still file a lawsuit, we go to court, and only settle 97% of the time after a lot of expenditure of time, money, productivity, and all of that. Then in the early 80s, also, the government began to use some money from a law called Law Enforcement, LEAA. It was money that Nixon had gotten to beef up the police, and in Carter's administration, they decided to use some of that money to establish mediation centers for the community. And those community mediation centers were mediating neighbor-neighbor disputes, family disputes, and so that began to take off. Then as more mediation went to court, the courts began to see this as a very positive thing, and in our court, the Supreme Court decided they would pass a court rule saying any party at any time during a lawsuit can petition the judge to order a case out of mediation. I'm sorry, out of litigation
into
mediation. And that set up a little bit more. But basically, I would say for the last, 10, 15 years, we've kind of reached a plateau because the mindset hasn't changed. People still think of resolving disputes, relationship disputes, by going to a lawsuit. And my thinking is how to change that mindset.
Can I offer a thought about that?
Sure.
Just that one of the resistance points on mediation is you want me to come in there and you want me to tell my story to a mediator and thus effectively tell my story to you. I'll be giving away my sacred jewels of information. I'll be giving you my strategies, my hidden advantages, and you'll use them against me if we fail in the mediation.
Well, two things, Jay. You don't tell the other side directly. The mediator will meet confidentially with each side, and that confidence is protected by law. Nothing said in the mediation can be used in the later court battle.
It's not admissible. Yeah. Rule 408, is it?
No.
Or is there a statute?
My gosh, it is a court rule.
Yeah, okay.
There is a statute in certain limited areas.
Okay.
Okay.
All right, so, it's not a problem then. In the remaining time, I would like to cover with you, though, what your platform is going to be in the Mediation Center, and I'd like you to discuss the pledge that you're going to incorporate in that platform.
The idea is that we're going to go out to different organizations that have common interests, like churches, like service clubs, Rotary and Lions, like chambers of commerce, people who have similar interests, and explain to them what I have just said in this show over the last hour. Using the adversary system to solve a relationship dispute between one member of this group and another member of this group is counterproductive. It's bad. It's a bad way to go. And at the end of the talk, to pass out a pledge for this group to say that if one member of this group gets into a dispute with another member of this group, that they will go and seek out a mediator before...
This isn't being done now.
It is being done now, but we're just starting.
That's a great idea. So it's like a special benefit for everybody who is in that cohort.
Right.
And they're all morally bound anyway.
It's only a moral, as a matter of fact, because we have so many members of the legal profession on the board of directors of the Mediation Center, we had to put a note that says that. But if I might, let me read to you, and this is not final language, it might be changed for one group to another group, but the idea is the same.
Okay, we're going to read this. This is going to be our final act in the show. This is the special pledge that Jerry Clay is going to deliver to the people, the organizations that he touches in his role as the chief executive of
president. I am
the
not
president of the.
I'm a volunteer.
Volunteer president of the Mediation Center of the Pacific.
Mediation is a process that brings people together to talk, rebuild relationships, and resolve conflicts creatively with the help of an impartial third person, the mediator. Core values of living in Hawaii is living with aloha and nurturing relationships. I, a member of this group, support these values by committing to use creative approaches to problem solving first before going to court. I recognize all relationships encounter problems. I further recognize that we often negotiate, compromise, and resolve problems in all relationships. I also recognize that in rare instances, problems may prevent disputes from being negotiated, hence we become involved in lawsuits. To promote aloha and nurture relationships, whether in business, at home, or in the community, I agree that I will strive to resolve all disputes outside of litigation using alternative dispute resolution processes such as negotiation, mediation, ho'oponopono, or other appropriate non-legal processes, with a place for people to sign their name, with a place for people to date it, with a place for the organization to be named, and then there's a statement at the bottom that says, "This pledge was created by the Mediation Center of the Pacific as an aspirational document having both moral and ethical commitment. It is not a legal binding document."
That's fair. So we're going to close now. I'm going to hold this up for the camera like that. And I want to say this is a very noble thing. What you're doing is noble. I mean, it's a career that has nobility to it, and I really appreciate it. I think a lot of people do, and you're known very well for that. I also think that inherent in what you're doing is a statement about Hawaii's special character. Ho'oponopono, aloha, it rings true through all that you're doing, Jerry, and I think you're making it possible, and this process is making it possible for us to be ahead of the game, ahead of the rest of the world. Thank you very much.
Been my pleasure. Thank you, Jay.
Aloha, Jerry. That's Jerry Clay. He's a lawyer who does lots of mediation. He is a mediator, and we've taken another look at mediation with him today. Thank you, Jerry.